Thank you, panel two. I'm Amy.
I'm Serena, and we are members of the BTLJ Symposium team. We are excited to introduce our third panel, which is called From Surveillance to Sentencing, Regulating AI in the Criminal Legal System.
Our moderator is Andrea Roth, who is joined by panelists Juliana DeVries, Rayid Ghani, Ngozi Okidegbe, and Nicole Ozer.
Hi, everyone. Welcome. Welcome to the panel on From Surveillance to Sentencing, Regulating AI in the Criminal Legal System. I'm going to be moderating. My name's Andrea Roth. I teach criminal law, criminal procedure, and evidence here at Berkeley. And we are lucky enough to have four distinguished panelists with us, whom I'm going to introduce very briefly before they talk. And then I believe we will have time for me to ask some questions of the panelists. And sorry, we won't be hearing from you all in real time, but we're all always available for further engagement. So first, we'll be hearing from Juliana DeVries, who's a Berkeley Law alumna and a clinical staff attorney at the Samuelson Law and Technology and Public Policy Clinic. And she was previously a clinical teaching fellow there. She also practices appellate and criminal defense as a solo practitioner. And before that, she was an associate in the Supreme Court and Appellate Group at Aiken Gump and an assistant federal public defender in San Francisco. We'll then hear from Rayid Ghani, who's a distinguished career professor in the Machine Learning Department and the Heinz College of Information Systems and Public Policy at Carnegie Mellon in Pittsburgh. Rayid was the founding director of the Center for Data Science and Public Policy, research associate professor in computer science, and a senior fellow at the Harris School of Public Policy at the University of Chicago. Before that, he was the chief scientist of the Obama 2012 election campaign, among other things. And he calls himself, quote, on his website, a reformed computer scientist and wannabe social scientist, but mostly just wants to increase the use of large-scale AI, machine learning, data science in solving large public policy and social challenges in a fair and equitable manner. We'll then hear from Ngozi Okidegbe, who's an associate professor of law and assistant professor of computing and data sciences at Boston University. Her work examines how the use of predictive technologies in the criminal system impacts racially marginalized communities. She's also a faculty associate at the Berkman Klein Center at Harvard and an affiliated fellow at the Information Society Project at Yale Law. And for the past 3 years, she was recognized with a Moorman Simon Interdisciplinary Career Development Professorship. And then finally, we'll hear from Nicole Ozer, who is a national leader in cutting-edge law and policy to advance rights, justice, and democracy, and also a legal expert in AI, privacy and surveillance, and digital speech. She previously was the director of the Technology and Civil Liberties program at the ACLU of Northern California. She was recently honored for this work with the Fearless Advocate Award of the American Constitution Society and a California Senate Members Association, resolution for unwavering dedication to defending and promoting civil liberties in the digital world and meritorious service to humanity. And she was also a Berkeley Law alumna. I should say at the beginning, just by introduction, that there's been a lot of media attention on the promise and perils of AI in risk prediction and evidence at trial. Today, we're going to do a deep dive into less scrutinized topics, including community supervision and discovery, challenges and opportunities with respect to tech solutions, including even in defining the problem, challenges in attending to realities of who has power to create, shape, and choose data, and also what's being done on the ground in California. So we will start with Julie, and I think you're going to share some slides. Take it away.
Thank you all for being here. To get us started, I'm going to talk about a few different AI technologies used in the criminal legal system. Hopefully, this will set the stage for the other panelists, including my more technical co-panelists, who I defer to on those things. So machine-generated evidence has been central to criminal trials for a long time. Professor Roth, in particular, is an expert on this. And now there are AI-based technologies being used in the criminal legal system as well. These can include cell site location data, ShotSpotter, facial recognition, predictive policing, and so on. I can't cover all of those technologies today, unfortunately, and Some are used in policing and don't come in necessarily as evidence at trial. I'm not going to address that important issue either. My work, done with the help of a number of terrific Samuelson Clinic students, right now focuses on technologies used in parole and probation. That is, people who've been released from custody, but are still being monitored by the state. So I'm going to focus on examples from that context. But many of the issues are the same, whether we talk about machine-based evidence at trial or post-trial. Law enforcement wants to use a new technology, perhaps to improve safety. Maybe they think it'll be more efficient, but it's not super accurate and reproduces the biases of the society. The defense doesn't have what it needs to defend against the evidence, and decision makers overvalue the evidence because it's science. But many of the issues with machine evidence at trial are exacerbated in the probation and parole context because of lower due process protections there. So a quick primer on parole and probation. When people are on parole and probation, they typically have a set of conditions of release with which they must comply. And if they violate those conditions, their probation or parole may be revoked and they may be sent back to custody or put in jail or prison for the first time. This is how actually a quarter of the people in prison in the United States got there for violating their probation or parole conditions. So it is important to understand. A person on probation or parole has a right to contest an alleged violation of their conditions at a hearing, but the standard of proof is lower than at trial. It's preponderance of the evidence. Hearsay evidence is typically allowed. The Daubert standard does not necessarily apply. It's usually not clear what discovery has to be turned over to the defense. In some states, people don't even get a lawyer, particularly if we're talking about an alleged parole violation. In short, there's complex technology evidence being used against people who have, I would say, little chance to defend themselves. Let's take a look at some of the technologies that I'm talking about. Okay, first, electronic monitoring. Electronic monitoring is a very common condition of release. In the United States, nearly 500,000 people are on electronic monitoring, many who are on probation or parole, but also people out on bail, pretrial, or monitored by immigration authorities. Some of these people are on traditional GPS ankle monitors for location tracking, but many are now tracked by smartphone apps instead. These are complex technologies with many different capabilities. They can track location, allow remote reporting to a probation officer, deliver calendar reminders, collect biometric data, track phone calls, even record ambient audio. There are serious accuracy and bias issues here. For example, some of the apps use facial recognition to verify that the person is with their phone. And facial recognition technology generally has been shown to produce false and biased results, often with the highest error rates for Black women. And the next generation of electronic monitoring goes even further than the current app. An app being developed by researchers at Purdue University tracks the monitored person's heart rate and other biometrics and uses artificial intelligence to communicate with them. According to the researchers' paper on this, the app then verifies progress toward healthy thinking patterns by measuring the bioindicators of lower stress via heart rate and blood pressure. As an accuracy point, it's not even clear to me that it's possible to measure stress using biometrics to measure it well. As a privacy point, it may be self-evident. This is personal health information. The developers of this app disclose more than usual because they're academics, but typically people being monitored know next to nothing about how their technology works on the inside. Another common type of probation and parole technology is the wearable alcohol monitor. Many people on probation or parole are not allowed to drink alcohol as one of their conditions of release. There are these wearable alcohol monitoring devices used nationwide to detect whether a person violated their no drinking condition. The most commonly used one is called Scram monitor. It's an ankle monitor, but there are wrist monitors similar to a Fitbit in development. They collect more data, so they probably are, hard to know at this time, but are or will be using some kind of machine learning or AI. Although there's a lack of transparency from the private companies that make these risk monitors and Scram. For Scram, the research has shown that it can produce incorrect readings because of, for example, another source of alcohol in the air or on your skin, and improper calibration, which is very important, skin type too. The sensor itself is only picking up the presence of ethanol, not the fact that a person drank alcohol. If the model is then trained based on that sensor data, the sensor picks up ethanol, only those problems are now baked into the model. So this is an example, again, of how the AI will be biased because of the data set. You can see I have a moldy peach and hairspray. That's because both of those will set off an ethanol sensor. I know this because I actually tried it myself. Risk assessments. These are tools used at sentencing and elsewhere. Basically, they're inputs and then the tool outputs a risk score for that person, like low risk, moderate risk, high risk. And the score can determine both the person's sentence and their conditions of release. Professor Okidegbe is really the expert on these, so I'll just be quick. But basically, these tools can be quite complex. They use big data and algorithms to generate the risk level. And there are reports of bias in these tools, which makes sense because the data, such as arrest records, reflect the bias of society, among other problems. If you have an AI tool that's using arrest data to predict future crimes, that's algorithmically reinforcing the past. Again, these tools are used in places where it's extremely difficult for the defense to get any information or to challenge the risk level. One place, for example, is at a person's parole hearing. They're hearing on whether to be released on parole. That people at those hearings don't typically have lawyers. What would it take to make fair decisions about human liberty using AI? Three things immediately come to mind for me. I'm sure others will speak about this, but first, transparency. Oftentimes what you have in criminal justice technology is a private company such as Scram that makes the product, sells it to law enforcement, and the company claims that key parts of its technology are proprietary and cannot be disclosed. No, people need to be able to request a lot of discovery about how the thing works and get that discovery, both the software, any hardware, how it works in general, how it works as applied to the specific person. This has to happen even at probation and parole and sentencing. Second, capacity. Once the information is disclosed, criminal defense attorneys, neutral parties, community members need to have the ability and resources to understand the disclosures, which may mean an in-house engineer at a public defender's office or outside experts that can do the work and get paid for it. This is quite far from the reality of the criminal legal system today. Like I've said, in parole, people typically don't have lawyers. I'm almost done. Even if making fair decisions about human liberty using AI were possible, and I'm not sure it is that even what we want as a society? I want us to think about that question. For example, if surveillance were perfectly accurate and unbiased, if it measures stress exactly right, does that actually benefit the collective? In the end, I think we come back to a lot of the same questions about our legal system, about mass incarceration, mass surveillance, racism, access to justice, what checks there are on government power, and so on. Ultimately, I don't have the answers. I hope there's some value to the asking. Maybe my other panelists do. I look forward to hearing from them. Thanks.
Thank you. As long as we figure it out in the next 55 minutes or so, we're good. Professor Ghani.
Thank you. I don't have slides. The benefit of not having slides is I can just improvise. So I'm not gonna repeat and agree with all the things that Julie was saying. So I'm gonna repeat those things and definitely not gonna give answers because that would just cut the panel short if I did that. So I mean, I think what I want to sort of start with is we were sort of talking about before this panel about the title of the panel, right? Regulating the machine. And I wanted to make sure that I think it's often sort of these things are provocative on purpose, but I want to make sure that we don't get stuck in that title. Because I was on a panel yesterday that was very similar. The topic was, who's accountable when machines cause harm? And I want to sort of go back to think, well, machines don't cause harm, people cause harm. We don't regulate the machine. We should regulate the humans, the ones who design the machine, the ones who deploy the machine, the ones who use the machines, and the ones who regulate the machines. And so I want to make sure that we come back to humans because, again, all of us are here because of the humans, not because of the machines. And if the humans were fine, if our society is perfect and wonderful, and no racism was there before the machines, and machines are only making it worse, then we shouldn't be having this conversation. And the answer is really simple. Get rid of the machines and go back to where we were. But we know that's not true. I mean, a lot of you have these careers because people have been doing horrible things and our society is not where we need to be. So the question becomes, is the combination of the two better or worse? Can we, and the way I sort of, I didn't start off thinking about these things, unfortunately, in my career. I stumbled on that by started doing work with governments and nonprofits and helping them design AI systems that would improve outcomes for people living in our communities, health outcomes, human services outcomes, employment outcomes. And what I realized very quickly is when we use off-the-shelf AI machine learning tools as built and used in, in the kind of off-the-shelf ways, it's not designed to get to racial or any kind of justice or equity. It's designed to purely improve efficiency. That's kind of the core of these tools. It's not doing that explicitly, but that's kind of what happens. And so the question becomes, is there a way to redesign it? Is there a way to build these tools that, one, improve and reduce the disparities that we're seeing today, but also can that be done in a way that can be regulated? Can these tools be regulated? Can they be designed in a way that they are regulatable? Knowing that the status quo is also not perfect. And I think criminal justice is a wonderful example of, we have terrible, terrible ways of evaluating the status quo. We don't have good mechanisms for evaluating judges, evaluating, lawyers. We don't have metrics. And when machines come in, we start asking for metrics, which is good. We should. But what I sort of often talk about is, a lot of these times AI is a really good Trojan horse because it forces these questions for, are you measuring improvement? Because if you're trying to design these measurements and evaluations for AI, then hopefully they push back to the human system and start benchmarking against some of these things. So I want to sort of step back a little bit and kind of talk about how, we're sort of seeing AI being used a lot, and while it seems promising, one of the things that's, and it can do a lot of things that only people were really good at. I think one thing that's important that's not talked about very much is AI is good at doing very, very, very specific things under very, very, very specific conditions. Despite sort of, ChatGPT, a general purpose transformer, it is not general purpose at all. It's trained to do very specific things. And one, we don't know what those things are. We kind of know, but we don't really know because we don't know how it's really trained. And so I think because of that, these AI systems, they generally, they're not one size fits all. which means when we talk about regulating AI, it's not about regulating AI. It's about regulating the process and the system it's embedded in. We can't just sort of say, here's this AI model that's used to do, alcohol monitoring. Can you regulate it? Well, depends on what it's being used for. You don't just regulate in isolation, because AI tools are not one size fits all, despite all the hype. And what these tools do is kind of, they mostly do what they're told to do, but they need to be told very explicitly and in ways that are not very auditable. And so a lot of these AI models and tools, they encode and operationalize our policies, our values. They encode assumptions about who matters, what type of outcomes matter, which people matter more than others. Those are policy choices, right? And they have huge legal implications. But as Julie was saying, they're often delegated to vendors and data analysts who have no training and no experience in making these decisions. They don't even realize they're making them. So you can't regulate a thing that people building it have no clue what they're building, why they're building it. People using them don't know how they were built. And then the people regulating them don't really know what questions to ask for and how to even look at this, which becomes a total mess, right? And so a lot of the time you sort of think about, what I often hear is, it's like, well, but there's a human in the loop that fixes everything, and that's a really risky path to take, because there's been shown repeatedly that human plus machine isn't better than human or machine alone. Confirmation bias is one example of why that's not true, but we've seen repeatedly that just by putting a human in the loop without testing, without evaluation, isn't the answer that a lot of people sort of give. And then a couple of things I would sort of say is, right, AI it's black box AI is not acceptable. So we have to be skeptical of that. But anybody who says that their AI is explainable, you also have to be really skeptical of that, because I don't know what that means. There is really, that's not a statement you can make and justify. Especially today, we're kind of in this awkward moment where those of us who are sort of building these technologies don't know why it works. Like in previous cases of other tool, like we could tell you when it works, why it works. Yes, it's complicated, but I can tell you why. And today, even the people building it don't know why it works, and more importantly, when it works. We try it and we see if it works, but we don't know before we actually try it if it's going to work. I mean, take ChatGPT, right? It was supposed to be a little demo that was put out for people to play with. They didn't think it was going to work so well that people would start using it. And so I think it's just, we have to be really cautious there of how we do this, because today's AI, in general, it's very immature, and not just immature as a technology, but immature as a field of researchers and practitioners. Like, we don't have standards, which makes it really challenging for lawyers to do discovery of any sort. Like, what do you ask for? Do I ask for the code? Do I ask for these models? Do I ask for the data? None of those things are enough, but we don't have standards on how these things were built. So everybody sort of comes up with their own standards, and we have to kind of figure out what we do there. And so I want to say, I think the thing I want to end with, right, is I think we have to sort of figure out how, I think not worrying about the kind of in these types of systems, I think thinking about regulating AI is going to be extremely difficult in the near to medium term. I think what we should be looking at is, how do we regulate the process and the system it's embedded in? How do we help this community kind of design standards that can be used to audit and regulate these types of technologies? And then how do we push towards evaluation methodologies that help us test? Right now, we don't know how well these tools work. We know how they work in isolation, but we don't know how well they work at achieving kind of the goals that we care about. And then if we're going to do any of these regulations, we kind of need to make sure that we have the mechanism, the skills, and the resources to do enforcement rather than just put out more words. So I'll stop here and thank you.
Thank you. It sounds simple.
Answer.
Professor Okidegbe.
Hi, everyone. I just want to start by thanking the student editors of the Berkeley Technology Law Journal and by thanking Berkeley Center for Law and Technology for organizing this symposium and the panel. And thank you so much, Professor Roth, for moderating and organizing us. And I'm just so excited to be in conversation with my panelists. As background, I write and research in the area of AI, computerized algorithms, and racial justice, with a particular focus on the criminal legal system. And my work primarily focuses on the democratic and epistemic consequences that the state's use of computerized algorithmic technologies has on communities directly affected by mass policing, mass criminalization, and mass incarceration. And so I particularly focus on politically oppressed communities. And reflecting on the theme of this panel, the theme of this symposium, I'd like to get us thinking about the role of democratic participation when it comes to the question of how to regulate the use of these technologies by the state. I wrote a paper in 2023 called To Democratize Algorithms. And in that paper, I explored the failure of the kinds of reforms that jurisdictions are implementing to address the democratic participation problems stemming from the state's deployment of computerized algorithms, particularly automated decision-making systems. These reforms typically aim to increase transparency and public participation in the processes that fuel the state's use of these technologies. And for the reasons I'm going to lay out in this short presentation, we all should be wary of these thin deliberative reforms. Not only do these reforms often fail on their own terms, but they're designed only to address how these technologies adversely impact the democratic participation of the public at large. They're not designed, unfortunately, to address how these technologies hinder the democratic participation of politically oppressed communities, in particular, communities marginalized on the basis of race, gender, class, disability, sexual orientation, as well as the intersection thereof and other statuses. And so if we really want to address the totality of the impact that these technologies have on democratic participation when it comes to the participation of politically oppressed communities in governance, then we have to move beyond the current approach. And so to illustrate that point, I'm going to talk about some of the common deliberative reforms and focus on the criminal legal context. But just to get us started, I want to talk a little bit about what I mean by this democratic participation problem. So to begin with, as many of you already know, algorithms are proliferating in the criminal legal system, and their introduction has led to shifts in governments and reflect shifts in governments such as privatization, resource rationing, as well as debiasing efforts. And the proliferation of computerized algorithms has been controversial. One reason has to do with the impact that the use of these technologies have on democratic participation. So now I want to lay out what I mean by the democratic participation problems. And the way I see it, and just to map it out, there are three distinct, though interrelated, democratic participation problems. So the first democratic participation problem concerns the fact that the public is given little insight or say into the construction, adoption, use, and oversight of these technologies, despite how these technologies affect rights, liberties, and also mediate our relationship with the state. And the second democratic participation problem concerns how these technologies makes governance less democratic. Because the state tends to rely on privately developed and sometimes privately implemented technologies, their use operates to set and in some cases alternatively undermine state policies and priorities outside the public purview, which in turn hampers the ability of the public to keep the government transparent and accountable. And when it comes to these two democratic participation problems, that concerns the public at large. But there's also a third democratic participation problem, and that concerns politically oppressed communities. And for these communities, the issue when it comes to the use of computerized algorithms, of AI, is not just that these technologies are often used opaquely or without public knowledge or input, both of which, of course, are problems. Rather, the problem is that the use of these technologies operates to entrench state practices that suppress these communities' democratic participation. And this suppression reinforces these communities' political powerlessness and governance. So to give an example, from the criminal legal system, many scholars have looked at how our criminal legal system reduces the political power of politically oppressed communities that are impacted by it. And so the growing use of computerized algorithms can operate to exacerbate that. For example, the use of predictive policing systems to concentrate policing in racially marginalized communities that can facilitate their arrest at higher rates operates to reduce their political power. And so, this is not inaugurated, of course, by AI or computerized algorithms. However, the use of these technologies are mediating this already existing political powerlessness. And it operates to maintain the ways in which the criminal legal system hampers the political participation of these communities. And what we see is an iteration of utilization of AI and algorithms that is particularly harmful for the political participation, democratic participation of politically oppressed communities. So what do we see happening on this front? So many scholars have as well as advocates, have raised concerns about the democratic participation problem stemming from the use of these technologies by the states. And jurisdictions are listening. They are turning to reforms. And I just want to talk about what some of those common reforms are. So these reforms tend to be discrete, thin, deliberative processes that are designed to increase transparency and public discussion around a specific proposal to use a specific algorithm or AI system in a specific context. So we're really talking about a technology by technology basis. And in many cases, of course, these reforms are connected to broader regulatory frameworks. I just want to briefly kind of discuss what the common reforms are. One reform is the public hearing model, pretty straightforward. It involves a government institution holding public hearings about a proposal to use a specific algorithm or AI system in a particular decision-making process. The second approach is the community control over police surveillance ordinances, which have become increasingly popular in recent years. There are at least 30 localities that have passed these ordinances. Just recently, Medford, Massachusetts passed one. Though these provisions with respect to these ordinances vary by locality, they share four basic features. First, they operate on the local level. They apply to local agencies, and agencies need prior approval from the legislative body in the jurisdiction in order to procure, use, or acquire funding for the technology. Even though it's focused on surveillance technology, that includes algorithmic ones. Second, in order to obtain such approval, the agency must produce a report outlining how the technology will be used and its impact on civil rights. And third, the legislative body can only approve this request after holding a hearing and considering public input about the proposal. And the local legislative body maintains ongoing oversight of the agency's use of the technology. And The third approach that we're seeing are stakeholder meetings. And under this approach, agencies are seeking to get community input by having stakeholder meetings with communities that are most likely to be impacted by the use of these technologies. And often that means politically oppressed communities. And there are some laws that have been passed in recent years that actually require an agency to actually hold stakeholder meetings before using such technologies. And here I'm thinking about Washington State Bill 6280 that so requires that. And so what are some of the limits here? I'm going to spend the short time I have left talking about that. And so first, there are enforcement problems. Many scholars have written about that. Professor Andrew Ferguson, for instance, at GW, as well as Professor Ben Sutherland have written about those enforcement issues. And that is a huge problem when it comes to how much these reforms can really resolve the democratic participation problems we see with these technologies. But even if we fixed the enforcement problem, my point is that the use of these reforms would help solve the first two democratic participation problems, the problems of democratic participation that relates to the public at large, but it wouldn't address the ways in which these technologies harm the democratic participation of politically oppressed communities in particular. And the reason has to do with the undue faith that these reforms place in transparency and deliberation. And there are limitations in both when it comes to transparency. I mean, transparency is incredibly valuable for politically oppressed communities, but it can also cause counterproductive epistemic harm. Professor Patricia Hill Collins has noted, and she writes a lot about standpoint epistemology, that all knowledge is political and ideological enterprise. So any transparency mechanism must contend with the fact that the government has the power to pick and choose which knowledge it produces and how it constructs that knowledge. And there's a consequence when we're relying on state-driven transparency mechanisms to fully understand the ways in which these technologies harm the democratic participation of these communities and how that can be resolved. And the second limitation has to do with deliberation. While deliberation is quite valuable, without addressing the power differentials that make it difficult for politically marginalized communities to deliberate on the same basis as politically powerful communities, we have a problem. There's issues of participation fatigue, issues of participation washing. And when we don't engage with the ways in which it's harder for members of politically oppressed communities to participate on the same level as politically powerful communities, we have to ask ourselves, what are we really doing when we are asking members of oppressed communities and putting that burden on them to participate in these processes when we know that there are these power imbalances? And so to conclude, I just want to say that if we're serious about redressing the democratic participation problems posed by these technologies, then we have to move beyond our current go-to reforms. We have to really think about transparency and deliberation with regard to power. We need to address power. We need to think about the power differentials in governance and society and how those imbalances will impact any reform that we go towards when we're looking at trying to address the democratic participation problems posed by these technologies. So excited for Q&A, and I'm so happy to have been on this panel. Thank you.
Likewise. Nicole, you're going to bring it on home and have the good news, right?
Hopefully some. All right, everyone. So I'm Nicole Ozer. Really glad to be bringing it home on this panel. I'm going to be providing a snapshot of some of the important integrated advocacy legal work across strategy that's happening in California to promote rights and justice and to really sort of build some of this collective power to address some of these democratic participation problems. These are not solutions in themselves, but they're certainly next steps forward to address these issues. And this work is happening across sort of many different strategies. In California, in terms of legislation, there are several dozen AI bills that were introduced this year. There is work happening in California agency and executive action. There is really cutting edge litigation that is happening in terms of California constitutional claims. And at the heart of this is really diverse coalitions driving this work across strategy that's been building really since 2018 and prior. In 2018, there was work that was done across a global coalition to really work on face surveillance, work on the local level. Some of those surveillance ordinances that were mentioned before were paired with actual prohibitions on the use of AI-powered face surveillance. There was work to pass state-level laws prohibiting the use of AI face surveillance. There was really active work in terms of corporate advocacy with diverse coalitions to push for moratoriums against the sale of face surveillance to government agencies. There was work on the federal level as well in terms of the introduction of moratoriums. So this really built and has continued to build since 2018 in terms of the diverse coalitions working across strategy to really power access and equity and justice in terms of the decision-making related to AI. In California, last year and this year has by far the most action on AI in the country. There are very consequential bills that are now at the final stages of the legislative process, and the governor will have until October 12th to sign or veto bills. A lot of these bills are actually talking about issues in terms of the process, transparency, notice, evaluation, due process in terms of correction. They're, again, not the solution, but they are part of sort of the process to make sure that there is more ability to engage in these issues and to have more power in the people to actually be real decision makers in what goes forward in terms of AI systems, particularly AI systems that are being deployed by the government and private parties that directly impact racial justice, economic justice, workers' rights, and democracy. There's also work at the local level that's happening. Some folks may not be familiar that there are some landmark laws here in San Francisco. There was a San Francisco AI inventory ordinance that was passed last year, actually spearheaded by another Berkeley law alum, my classmate, former supervisor Hillary Ronen. Again, not a solution, but another step to make sure that there's actually some information and more disclosures so that there actually are opportunities for community groups, and particularly those impacted, to be able to at least come to the table to know what's happening in local communities. Another area where a really diverse coalition came together to address is Governor Newsom in California issued an executive order more than a year ago that created a really fast timeline on AI deployment by state agencies. The ACLU, where I worked for almost 21 years, we did a civil rights framework for agencies considering AI and really focused on some of what was talked about in some of the early panels about the absolute critical importance of the why, whether, and who before the how of whether AI is used, deployed, or built, and to create a robust process to make decision-making and use transparent and accountable to those who are most impacted, and mechanisms to ensure that AI systems are built carefully. So this was beyond transparency and notice. This is really about embedding real power in the people that are impacted and the people who are the ones who the most harm actually occurs to when these systems are put out and not considered and built carefully, including an AI impact assessment and evidence-based evaluation of whether risks outweigh the benefits. Too many times we see government or police departments just claiming that the benefits to public safety outweigh the risks to the people. This was really embedding a real evidence-based evaluation and forcing those deep conversations, and that these AI systems absolutely should just not be used for any high stakes decisions in criminal, immigration, and policing systems, just taking that AI use completely off the table, and robust evaluation. Some of these principles in those civil rights assessment and the advocacy that was done by organizations, including my own and many others in California, led to a state of California guidelines that were released in December 2024. Again, the things that were advocated for, not all of them, very few of them made it into the final guidelines, but we were able to at least get some stakes in the ground on the importance of these issues. To require the equity impacts on vulnerable communities, to assess the degree and scale of these impacts, and select ways to manage risks if a Gen AI tool is adopted. It requires that there be a pre-procurement equity evaluation process to engage with impacted vulnerable communities, to gather feedback, concerns, and insights, and to potentially rescope the use of that system or consider alternative solutions. So the fact that even this conversation and these requirements are in, that forces not just engagement with the general public, but with impacted vulnerable communities, we felt was an advancement over what we had been seeing previously, where systems were just being deployed with absolutely no consideration, and particularly not the engagement of the communities most impacted. And that has to be continually assessed and monitor the impact of the tool on vulnerable communities. Requirements for accountability, for fairness, for human oversight, and transparency. In addition to the work that's happening on the legislative front, on the executive and agency front, there's also important litigation that's happening. This is the Robert Williams case. Robert Williams, who is a client of the ACLU, eventually was improperly arrested with face surveillance systems, and led to a good settlement. Again, not a solution, but at least some much stronger standards for the Detroit Police Department in use of face surveillance in the criminal justice system. Also litigation against Clearview AI, which permanently banned Clearview from making its FacePrint database available to businesses and private entities nationwide, and barred it from selling access to any entity in Illinois, including state and local police, for 5 years. And some of what I'm most excited about right now is the litigation that's moving through the California courts to hopefully revitalize the full reach of the California constitutional right to privacy. There's a really important case, Renderos versus Clearview, brought by Just Futures Law and Braun, Hagee, and Borden, that's representing racial justice and immigrants' rights activists. It includes a constitutional right to privacy. Actually 2 years ago, for this BTLJ Symposium, the focus was actually on the California constitutional right to privacy and utilizing it more fully to promote racial justice and access and equity and justice in the AI age. And I worked on that symposium and was able to follow up with a longer law review article on this topic. So I've done a very deep dive into the California constitutional right to privacy. It's a very exciting area where I think that there's a lot of potential, and we're working in broad coalition to think about the types of cases that we can bring in California courts that can potentially move up to the California Supreme Court. For those who've never seen the California constitutional right to privacy, it's in Article 1, Section 1 of the California Constitution. In 1972, the voters added 3 very consequential words to Article 1, Section 1. They changed the word men to person, and they added the words "and privacy" at the end of Article 1, Section 1. And with those 3 words, they expanded inalienable rights to every person of every age in the state of California, not just citizens, but every person, and made privacy an inalienable right. This is what the voters saw in 1972 when they went to the ballot, when they went to the polls to vote on Proposition 11. It is the most comprehensive right to privacy in the world. It covers both autonomy privacy as well as informational privacy. It's far broader than the Fourth Amendment. It protects both against government privacy intrusions and private party privacy intrusions. And it was really created to give an inalienable right to privacy that really addressed the fact that there was so much increase in terms of stockpiling of information in the dawn of the technology age. As the California Supreme Court highlighted in its 1975 decision in White v. Davis, which was the first California Supreme Court decision to analyze the scope of the California constitutional right to privacy, that this right was really, its moving force was a real focus on the accelerating encroachment and the impact of increased surveillance on people's rights and safety. The ACLU of Northern California, we did an amicus brief in the Renderos case, where we really focused on the fact that face surveillance, the use of face surveillance, really implicated multiple privacy mischiefs that were supposed to be addressed by the California constitutional right to privacy as identified by White v. Davis, including government snooping, overbroad collection, the lack of reasonable checks, and the improper use of information collected for one purpose and used for another purpose. These are some just follow-up materials. We'll also, I think, have those in the MCLE documents, but the amicus brief in the Renderos case, a recent article I wrote for the Brennan Center for its State Court Report, the longer law review article on the constitutional right to privacy, and the comments to Governor Newsom on the civil rights framework for AI decision-making. Thank you very much.
Thank you, Nicole. We have a little over 10 minutes, and you all have identified a number of problems, and I do know that understanding the problems is 95% of what we're trying to do with a panel like this, and lots of panels going on around the country like this. So I'm going to totally unfairly try to, and keep up with the optimistic note to see, given that our audience members are lawyers, community members, law students, lawmakers, and the research community, I'm wondering where we should prioritize what is limited bandwidth that we all have right now, physical, cognitive, emotional bandwidth, where we might get the most bang for our buck, and make sure that we don't fall into the traps that you all have identified in the meantime with like too easy solutions. So I'm wondering, there's so many places that we can intervene, getting designers to focus on building more equitable tools and then making those marketable so that they crowd out the worst stuff. Legal bans, robust requirements, constitutional litigation in sympathetic states, crowdsourcing audits, trying to see, reducing the load on individual marginalized communities, but maybe still getting the public involved when they do have the bandwidth. So I'm just wondering, again, totally unfairly, and we probably have enough time for like a 2-minute riff from each of you, but do you have thoughts on, where to start that would not be a trap, but would also just sort of allow us to start doing something once we understand the problem. So maybe we can go in the original order. Julie, I don't know if you want to jump in.
Okay. So we've talked a lot about transparency, and I like that I said, let's do transparency. And then Professor Okidegbe said, no, that's wrong. That's a great panel. So so when I talk about transparency, usually I'm talking about discovery in an individual criminal case. And as I see it, this is not perfect at all, but that's at least giving the information to the person who represents the individual who's impacted by the carceral state and to the individual themselves. And that's a bit different from the procurement or third-party testing side. And maybe you have thoughts on whether those are different or not. And I do think it's such an important issue to center the people who are most impacted by the decision and the decision making. I think it has to be a variety of voices. There's never one perspective, for example, that represents people who are incarcerated or on supervision. And I mean, one thing that comes to mind as far as ways to do this are I tend to believe in small nonprofits that are true community groups. One that I like is Uncommon Law, which helps people try to get out on parole in California. They have lawyers, they have impacted community members who work there too. Everyone works together, and the partnership maybe helps with some of the exhaustion problems of just saying like, oh, like, everyone come participate, even though, you know, you may be afraid to leave your home because of immigration fears or something. I tend to believe in 1,000 little reforms, hopefully all pointing in the same direction. So I do think the work of everyone here matters, and I appreciate it, but, you know, who knows? We're doing our best.
And discovery, unless there's a gag order or an NDA or something, can also give that information to a public who could crowdsource audits, presumably, or the research community. Okay. All right. Professor Ghani.
So I don't think we can rely on the designers, and I can say that as, you know, somebody who spends a lot of time building these systems. There's too much heterogeneity in how these systems are designed to sort of hope that everybody with their own made up standards and methodologies kind of do the right thing. And so I would start from the opposite extreme of give them, I think there are lots of, you know, I think, Nicole, you talked about a lot of things that have been passed in California. They are all wonderful, but they're mostly words, unfortunately, from my perspective. They're not, you can't operationalize them as an AI developer because they're still ambiguous, even though they're legalese, they're still ambiguous legalese. And I what I really want is some regulations that can be operationalized at the technical levels so that there is a way to hold the people developing and deploying accountable. So when we talk about sort of like, oh, it needs to be fair, like, well, what does that mean to be fair? We've been talking for, you know, centuries about fairness. But that doesn't mean that, and then it leads to, you know, ambiguities and then gray areas. And the challenge is that when people are building these AI tools, they're coding those gray areas and they're picking one side arbitrarily. So unless they're kind of told very clearly, same for kind of the discovery and transparency, right? If in discovery, there's no way to expose the problems because they can give you the 3 million lines of code, but you don't know which line is the one that encoded the most important thing in there that caused that the thing you didn't want to happen. So I think it has to be kind of very clearly, I think it's more top down than bottom up, where here are the rules, here are kind of operational guidelines, here are the standards. Now follow them. And I think the way to, in my mind, to get there is really focus on procurement as the vehicle. Because if the procurement process asks for all these things, the vendors will fall in line. But that does require equipping and training the people procuring these tools to have the skills or the expertise and or collaborators who can help them do this kind of stuff. But my approach in this case will be top down, because we're not gonna get there by letting each developer sort of figure out on their own, and that's, you know, that's possible. It's just not likely. But if we have kind of the standards in place, and then we have the procurement teams asking them, here's what we care about, here's what we want, here's how we're going to evaluate you. You need to expose these things in this format so that we can compare and run evaluations, and they have to happen, you know, every year, and it's monitoring. All these things are built in. Then I think the vendors will find it harder to not follow those if they really want to be competitive.
And you're going to write those model procurement requirements for all of us, right? For the
So there is work happening. There
yes,
are a
yes.
couple of groups that are working on that. There's a group called GovAI Coalition that's kind of based out of sort of San Jose. They're working to put out templates. There's another group as well. We actually, the National Academies, I worked with them to put out sort of a guide for local and state agencies to incorporate AI into their processes and procurement guides. I think that's the intervention that I think could have near-term impact, because that's the place we all go through.
Okay. Professor Okidegbe?
Yeah, I just, and thank you so much for this panel. I'm not anti-transparency. I just want to say that, just to make sure I'm on the record. I do think transparency is incredibly valuable, and we see a lot of community groups using transparency to litigate against surveillance technologies that are harmful to marginalized communities as well as the public at large. So I'm very in favor of transparency, and I really appreciate your presentation, Julie, and it made me also think about the work of Professor Rebecca Wexler, and thinking about the importance of transparency when it comes to criminal defendants and the use of technologies in her case, as well as thinking about Professor Roth's work. So I think transparency is important. I just want to if I may, I love the question. I think to me, I think it is a bit important to think a little bit about like who's using the technology and who we're talking about. I do think I agree with Professor Aziz Huq, though I know not everyone does on this point, with respect to the idea that it's different when the state's using the technology versus, when we're talking about private companies. It's different when we're talking about the public than we're talking about particular individuals. And so it kind of affects how I think about these solutions. But if I'm thinking about the problem I surfaced, which is democratic participation, I think that there are some models that we can think about. And here, I think about Professor Michelle Gilman, who's at UBC's work, where she gets us to think a little bit about, look at the administrative context, right? We have the National Environmental Protection Act of 1969 that has environmental impacts statements, and there's a lot of questions around algorithmic audits and impact statements, and there's ways to involve communities there. But of course, that's only a starting point. The bigger thing, of course, is when we're talking about questions of fatigue and we're talking about questions of participation washing and how we involve these communities. I think we should be very conscious about when we're involving these communities, why we're involving these communities, and I think we should compensate communities as well for the work that they do, whether it's the community group or individual community members, and really take seriously what we're doing. I think the state should have an obligation, an agency should have an obligation to actually respond to the comments that they receive and why they decided to go the route that they went, particularly if they don't agree with the community, and to take really seriously the point that these are often very complicated technologies that we're talking about, and communities don't necessarily have the technocratic or technical skills to fully understand it. I'm gonna take the controversial position that perhaps we don't use technologies in the criminal legal system that are black boxes, and I think about Professor Chris Sablogin's book, Just Algorithms, where he makes this point, and I've made this point in my work as well, that there are technologies where it's going to be, nearly impossible for communities to have a say, as well as even those with the technical skills, just because of the kind of technology it is. And the question becomes, should we use these technologies? Perhaps we ban these technologies with respect to the state, at least until we have a way of understanding them well enough for communities to have a say. But of course, that goes against this idea of kind of a techno-optimistic viewpoint, and idea that we want to go in the direction of implementing new technologies as they become available. So those are some of the things I think of bans and thinking about strategic ways of involving communities.
Thank you. Nicole?
Well, I'd say, we want to use technology to actually improve lives for people. And so that's at the core, it's not technology for technology's sake. And I think that goes back to the why and the whether before you jump to the how, which is where so much of the conversation is. And at the core to all of this, as was brought up before, is really power. Transparency is necessary, but not adequate. But while we see so many bills or local ordinances only have transparency, is because there isn't power to pass something more robust. And so it really comes down to power and sort of having the resources to actually build that collective power, to have the structures, as we were saying, for folks actually to be able to engage in this work and in these opportunities. I mean, even just the time of most city council meetings is not conducive to people who work and have families. So there's all sorts of structural systems that undermine the ability for folks who are most impacted to actually not just speak, but also it's the speaking, but it's also, are there requirements to actually be listening and taking that into account? And so I completely agree. You know, as somebody who crafted the surveillance ordinances almost 12 years ago, those were sort of meant as a first step. Now it's important to go into the next stages to learn what worked there, what didn't work there, how do we actually embed the ability to make sure that real decision making is in the power of the people rather than it just being sort of superficial, you know, ticking of the boxes. Yes, we heard from some people, but we didn't actually listen to those folks. And I do think that in terms of building power, it's really important to do integrated advocacy across strategy, because those different strategies create virtuous cycles, which actually create more power and more support for the other strategy. So my answer is it's a both and, but it requires strategic thinking and the right kind of coalitions to be developing those ideas from the beginning that actually bring in those diverse voices. So you're thinking, you're identifying the problem together. You're crafting the solutions, and people are taking those pieces, and we're actually reinforcing each other's work and reinforcing the narrative, which is one of the biggest problems we have, is that we're up against the most powerful forces, the biggest companies in the world, government. We're always the underdog in these fights, so we have to work smarter, more strategically, more collaboratively. That's work I've tried to do, and I'm excited about this next iteration, this panel, and folks in this panel and others, that hopefully we can get to the next stage of this work.
Thanks. Thank you to the four of you for the work that you're doing and will do on these issues. Thanks to our audience for engaging with us. And thanks for speaking hard truths and also being hopeful. So lovely to see all of you. And I'll turn it over to our hosts. Take care.